and it was over, 3-year probation. And so I went to the probation office, and I showed him the public record. And I tried to stop the probation from ending. I thought he should still be on probation to protect the citizens of Nassau County against things that he had done and had a long record of doing, a long public record of doing. So Scott Lord, with all these defaults in the bankruptcy court, not showing up for the 341 meetings and not answering the summons, and not coming when called, he takes out a motion to Judge Hall, the bankruptcy court judge, to vacate all of his defaults. Well, naturally, I opposed that, and that was with hundreds of pages that I sent to the bankruptcy court why his faults should not be vacated. And there was a hearing on that before Judge Hall in Westbury, and I went all the way down from Westchester County to Nassau County to be at that hearing, and I heard Richard O'Connell present his case why the Scott Lord's default should not be vacated. And then I asked Judge Hall if I could speak, and Judge Hall denied me an opportunity to speak. And then the trustee decides to settle with Tri-State. Remember, the Tri-State was $105. That's what the trustee, $105,000. That's what the trustee said the fraudulent conveyance was with Tri-State. Then the trustee decides to settle with Tri-State for $5,000. To me, there's a big difference between $105,000 and $5,000. So right there before your eyes, you saw the bankruptcy estate dwindle by $100,000. And the trustee gives all kinds of reasons. This is Trustee Richard O'Connell. Now, he's a panel trustee. He's not the United States trustee. And he gives all kinds of reasons that Tri-State doesn't have $100,000. And that the money that was taken out of the estate, part of it was the salary of Scott Lord, and part of it was for equipment. And that Scott Lord had not told Tri-State the truth, that Scott Lord had said that he had something like 105 active accounts or 300 active accounts, and it turned out he only had 100 active accounts. And that the equipment that Scott Lord said that he had when he sold his company to Tri-State didn't amount to the figure that Scott Lord said it had. So they downsized the deal of selling the company, the Atlantis, from like $100,000 down to $55,000 and so forth. And to me, the trustee should have known all this. Don't you think? He should have known exactly what this was worth. He shouldn't have been hoodwinked. Missing the mark by $100,000 is a big shot. It's like, 80% error. When the company's, when he hits them for $105,000 and then decides to settle for $5,000. So certainly I oppose that. And I went to that hearing of O'Connell before Judge Hall. And I asked again to speak to that at that hearing, and yes, I was allowed to speak. And I said that Tri-State had a mortgage that I knew of for something like $110,000. That was in the Nassau County Clerk's office. And so I said they did have the assets and they could pay. Well, as it turned out, Judge Hall, first of all, he signed a order not to vacate Scott Lord's defaults. And I want to read you something about that, just a second. This is under the signature of Richard O'Connell, the panel trustee. And this is what he says. This is his last statement on the vacating Scott Lord's defaults. This estate currently has no assets because Mr. Lord transferred them to Tri-State and then falsely swore that no transfers had been made. His filing of the Atlantis bankruptcy petition was, at the very least, a cynical attempt to manipulate the bankruptcy system and to mislead his creditors. His default in appearing and answering was not a brief lapse, rather more than 3 months elapsed from the last date upon which Mr. Lord might have answered to the date that he made his instant motion, the motion to vacate his defaults. Under the circumstances, Mr. Lord's default should not be vacated. Wherefore, plaintiff Richard O'Connell respectfully requests that defendant's motion be denied in all respects, dated Flushing, New York, March the 15th, 1991. Richard E. O'Connell, trustee. Yost and O'Connell, attorneys for the trustee, 16124 Northern Boulevard, Flushing, New York, 11358, 718-358-5520. So Judge Hall did not vacate Scott Lord's defaults. Now, Richard O'Connell submitted his motion to Judge Hall to settle all the monies against Tri-State, $105,000 for $5,000, and Judge Hall signed that order. So the estate had, instead of $105,000 in it, it had $5,000 in it. Now in 1992, Scott Lord called me and he offered to settle with me. He wanted his license back. He didn't want to work for Jan Stahl and Jeffrey Barnes. He didn't want to work for Tri-State Irrigation. He wanted his own company again. So he applied to Consumer Affairs under a new name every year, under a new name for his company. And he applied to get a license. And Consumer Affairs told him that he had this judgment was against him, this judgment with Glendora. And so Scott Lord decided to make peace with Glendora. And so he offered to pay Glendora $1,000 a month in 1992. And something like 5-6 months payment. Or was it $500 a month? Or something like that. And Scott Lord, having defaulted to Glendora in every arrangement that he'd ever made with Glendora, way back to the contract of 1986, way back to 1988, when through Consumer Affairs he was going to settle with Glendora and settle the judgment and get his license. And then through the thing with the Article 78 with the County of Nassau and Consumer Affairs, and he reneged on that. So here he was with another one. And I could see pretty well that he would renege on this. So I let him go and talk about it. And sure enough, he reneged on that. And he wrote this false letter to Consumer Affairs, which I'll read you, if I can find it. On September 22nd, 1992, I wrote you concerning payments that I am willing to make to Glendora. I will make these payments under duress, as this is the only way I will get my license back. I would like to point out to you that this debt, according to the bankruptcy law, does not legally have to be paid. Well, that's not exactly so either. I am paying this debt so that the harassment that has been going on will stop. It has not been harassment. I had every right to try to collect the money that he cheated me out of up until the time he went bankrupt, and then he gets an automatic stay. And then the bankruptcy court takes over the bankruptcy estate and Richard O'Connell. I also understand that you cannot agree to these arrangements. I have offered these arrangements to Glendora, but she does not want to take them. I will be sending her the money, and I'm sure she will not refuse any of my payments. Well, he never sent any money. He never sent any money at all. Please contact me to advise me of your position in this matter. Sincerely yours, Scott Lord. I'll show you that. Then he wrote another letter to Consumer Affairs very soon after that. That was also false. by now you can surely see that it's not in the best interest of the creditors to settle the tri-state thing from $105,000 down to $5,000. That is not in the best interest of the creditors, is it? So then the trustee, the panel trustee, comes along with this one. He gets a judgment against Scott Lord for $55,000. Scott Lord, in other words, has to pay the estate, the creditors, $55,000. And Judge Hall signs the order for that. So in Judge 5, 4, 3, 2, 1, in Scott Lord's own words, at the time he wants to settle with Glendora, he tells her that the bankruptcy backfired. See, Scott Lord was hoping to get rid of all of his creditors through the automatic stay of the bankruptcy law by going bankrupt, and then he could get his license, he thought. But this didn't work either, because he gets a judgment against him for all of these fraudulent conveyances for $55,000. Now, the panel trustee comes along, and guess what he's going to do now? He makes So we have this judgment against Scott Lord for $55,000, and then the trustee comes along and he makes an application to the bankruptcy court to settle with Scott Lord for $12,000. Is this in the best interest of the creditors? We had a $55,000 judgment against Scott Lord, and now the trustee wants to settle it for $12,000. Don't you think there's a big difference between $55,000 and $12,000? So naturally, I oppose that. And this is my application or my counterclaim against that. And not only does the trustee want to downsize the payment from $55,000 to $12,000, he wants to give Scott Lord time payments. He's going to let Scott Lord pay these at $1,000 a month over a period of 12 months, and it's supposed to be all paid up in October of 1993. Now that is the worst of both worlds for the creditors, and it's the best of both worlds for the debtor, Scott Lord. If he's going to downsize the amount from $55,000 to $12,000, then Scott Lord, in addition to that, should not get time payments, right? So he puts this before Judge Hall, and as I say, I oppose it with this motion here to make Scott Lord pay the original $55,000. And Judge Hall, right then and there, and I appeared at the bankruptcy court and I opposed it. And Judge Hall said, he told me to sit down, and he hadn't read this, and he would not let me play my evidence of the names that Scott Lord had called me over the telephone. And the marshal, Joseph Derby, had taken my recorder. When I went in, I wasn't going to record, I was going to play back the evidence. And when it came time for me to play back the evidence, Joseph Derby would not produce my recorder so that I could play it back for Judge Hall. And Judge Hall just sort of glossed over this. He didn't allow it to be heard. And so he wouldn't let me read this at the hearing either. And it just turned out to be that, again, I did not get my a day in court. Then something very, very, very interesting happened, and I'll tell you about that. And before I tell you about this next interesting thing that happened, I just wanted you to know I had to go to the library, and I had to read all that. That's the bankruptcy code. There's a bankruptcy code, the bankruptcy law, and then the bankruptcy rules. So I had to read all that stuff. And that took about a year. That was from 1992 to 1993. I finished it in the first quarter of 1993. So let me tell you this next thing. Bearing in mind all that you just heard, and with Judge Hall not giving me a chance to be heard, and with the trustee never giving me the information that I'm entitled to have as a creditor, it should be on file in the clerk's office. And downsizing the tri-state from $105,000 to $5,000, and downsizing the judgment against Scott Lord from $55,000 to $12,000. Okay, and with all of the negligences, and with all of the, just letting things go on and ignoring it and not doing the job, finally, around the middle of March of 1993, I sued 11 defendants in the Westchester County Supreme Court, and I sued them on negligences, 65 counts. And it was Glendora, plaintiff, versus Judge Conrad Duberstein. He is the head judge of the whole Eastern District. He's headquartered in Brooklyn, a bankruptcy judge, and he's Judge Hall's boss. And I had sent him, I'd sent out letters practically every week pointing out the things that weren't being done and the things that were wrong and the things that were unjust. He totally ignored them. So I sued him for that negligence. And I sued Judge Robert John Hall for all of his negligences that had piled up. And the panel trustee, Richard O'Connell, unbelievable pile of negligences. And the United States trustee, Harold Jones, down in Bowling Green in Manhattan, because he's the head trustee, and he'd been informed all along of these things that were wrong. And he did nothing about it. He chose to do nothing about it. Neil Mann, the assistant United States trustee. Teresa Kavanaugh, the assistant United States trustee who replaced Neil Mann. The United States attorney, Andrew Maloney, because he had been informed all along about these wrongs, and he chose to do nothing about it, although he did send us one letter, and he did say that he would start an investigation into the criminal aspects of Scott Lord. And then who else? The marshal who denied me my audio tape evidence to present in court. That would be Joseph Derby, and Scott Lord, and Jan Stahl, and Jeffrey Barnes. Those are the 11 defendants. I have to insert something here that I forgot to tell you. I made a motion to Judge Robert John Hall to ask the United States Attorney to conduct a criminal investigation of Scott Lord, Jan Stahl, Jeffrey Barnes, Atlantis Lawn Sprinklers, and Tri-State and its division, Atlantis Lawn Sprinkler Systems. And Judge Hall, or somebody, sent that motion back without any name or any date or any explanation. They just sent it right back. Did nothing about it. That was another negligence. Oh, so now to continue. The summons with notice said to those 11 defendants that they had to have an answer into my complaint, which was, it was a long thing. It was about 28 pages, and it was 65 counts. That they had have to have their answer in by about April 16th. Well, Richard O'Connell answered. His defense really had no merit. And the federal defendants never answered. They never answered and haven't answered to this day, and it's July 4th. They haven't answered to this day, and they were represented by a lawyer named Novinsky. Jan Stahl wrote a letter and said he had no interest in what I was saying. That is hardly an answer. So the next thing, of course, I have to file the Federal Tort Claims Act. I have to file the administrative claim. And here they are. I filed 4 of them. The Executive Office of the United States Attorneys, Department of Justice, that's called USAO, and of course that would be for Andrew Maloney, former United States Attorney in our area. L. Ralph Meckham, Director, Administrative Office, U.S. Courts, 1 Columbus Circle. These went out about the middle of August, 1993. That would be for the two judges, Judge Duberstein and Judge Hall. And this one is the General Counsel, Executive Office, United States Trustees. That would be Martha Davis. You know who she is. And so that would go for Kavanaugh, Jones, and Mann, United States Trustees. And the last one is the Senior Associate General, Counsel for Litigation, U.S. Marshal Service, and that would be for Marshal Joseph Derby. Now this form is a very simple form to fill out. It's one page, and over in the back there's 2-3 questions, yes and no. And it's as simple as that. You send it to the agency, and the agency has something like 6 months to accept your claim or to deny it. And if you don't hear from them in 6 months, you can assume that it's denied. Then this mailing, with its printing and with its postage, cost $102. $102. And this is the 106th mailing. The others haven't been quite that expensive. So somebody has to pay for that. This is a Katy cat. The biggest thing, of course, that happened is that September 8th came, and we started our 8th year of trying to find justice out of the mess that Scott Lord made of everything, out of lying to us, stealing, and cheating, trying to make good that. So we started our 8th year on that. I met Scott Lord on September the 8th on Oyster Bay Road, out in Plainview, Long Island, Nassau County, or that is Nassau County, isn't it? It's pretty. The administrator of the United States Courts in Washington, D.C., and wrote a very, very nice letter. And so I apologize, and I made out the administrative claim, this time I hope correctly, and sent it back. Their work was beautiful. The work that they sent out was just beautiful. And then I talked to the marshals. And true enough, with the marshals, I hadn't signed that one either. That's in Arlington, Virginia, which is Washington, D.C. And the nice young man from there talked to me. His name is Joseph Lazar. And so I sent out a new administrative claim. This time, I hope correctly. I also heard from Martha Davis, who had a lot to do with the adversary proceeding that was started against Scott Lord, Jan Stahl, and Jeffrey Barnes for the fraudulent conveyances in the bankruptcy. So I heard from her that there were defects in the way I made out the administrative claim. So folks, I did that over again. I'm very sorry about that. I'm very embarrassed. So that one is done. Now the fourth one, who is that? That's the United States Attorney's Office. And I sent apparently Mr. Meekums, who is the administrator of the United States Court, I sent the attorneys to him, and the administrative court I sent to the attorneys. So I hope I've corrected all that, and I hope I've got them all out. You understand what the administrative claim is about. I have to say that these people did all these bad things, Judge Hall and Judge Duberstein, and the 3 United States trustees, Mann, Kavanaugh, and Jones, and the United States Attorney, Andrew Maloney, and the United States Marshal, Joseph Derby. That they did all these bad things, and I was making a claim for these. And for each of the agencies, the 4 agencies, I make a claim of $12,500, and for 4 of them, that is $50,000. Mr. Lazar told me that, Lazar, that's an interesting name. It's not L-A-S-E-R, though. It's L-A-Z-U-R. That's concentrated light. Mr. Lazar told me, Lazar, said that probably they would all get together, the 4 agencies, and one of those agencies would be chosen to handle all 4 of them. That just one agency would be chosen to handle all 4 claims. What else is new? Oh, in my affirmation in support of Richard O'Connell's application to settle with Judge Hall, the Scott Lord payments. Remember, Scott Lord defaulted in his payments. Scott Lord's always defaulted with me. I've never known him not to default. But the trustee minimized those assets to the estate. So at this point, the best thing to do is to support O'Connell on that. What else happened that we keep every day on what is happening with Glendora versus Scott Lord, Jan Stahl, Jeffrey Barnes, and all those other people? This is a very sad thing. Did you see where Judge Wackler got 15 months? Remember Judge Wackler? You saw him here on a chat with Glendora 8 days before he was arrested. There he was, everything a human being should be. Remember, he was jolly and witty and vigorous and full of vitality and likable and smart. And in the back of his mind, all of this crazy stuff is going on. It's really a sad thing how hard he hit the bottom. All right, another notable thing that happened with Glendora versus Scott Lord et al. The week of September 6th was along about the first of the week, Scott Lord telephoned me. And I'd like to have you hear that conversation. I'd like to find out what Scott Lord is like. And this is the Supreme Court of the State of New York, the County of Westchester, Glendora plaintiff against Conrad Duberstein, Robert John Hall, Andrew Maloney, Harold Jones, who was a United States trustee, former, Neil Mann, who was an assistant United States trustee, former, Teresa Kavanaugh, a current United States trustee over in Garden City, and Richard O'Connell, the panel trustee, Joseph Derby, the marshal, Scott Lord, the bankrupt, the debtor, Jan Stahl and Jeffrey Barnes, the two people Scott Lord committed fraudulent conveyances with. Conrad Duberstein is the chief judge of the Eastern District Bankruptcy Court. That's Brooklyn, Nassau, and Suffolk. Robert John Hall is the judge that I said was negligent in handling this case, and he's in Westbury. He's a bankruptcy judge in Westbury. Notice of cross motion, and this is to the Honorable Samuel G. Fredman. That's remember, Judge Cattell remanded, he severed the case, okay? Those above, all those federal defendants, the 7 federal defendants, he said everything had to stop, and I had to file a federal administrative claim to 4 agencies about those 7 federal defendants, and then the 4 non-federal defendants, he remanded to the state court, where whom I promised to remember. Hi there, Robert. And Peter, Boss said to him that there must be something to reincarnation. After all, there must be some truth to reincarnation. He says, did you ever notice how all of the office workers seem to come back to life at 5 p.m.? And Pat gave, this is the advice that Pat gave to his 4 sons. One was, work like a dog, eat like a horse, think like a fox, and run like a rabbit. And don't forget to see your veterinarian every month. And did you hear about the absent-minded professor? He was in the revolving door. He couldn't remember whether he was coming or going. And Patricia and her friends, her girlfriends, belong to a hiking club, and they call it the Walkie-Talkies. This is Glendora, a cheerful look at life now. Folks, keep the courage flaming.